Okay, it looks like people are getting settled into the waiting room. So, welcome, welcome, welcome. Good evening, everybody. And thank you for joining us for another evening with Judge Philip Smith as we talk about family matters with Judge Philip Smith. So, we hope everybody is doing well, taking precautions out here as you engage in your daily lives and kind of get a little snatch back from getting back to normal. And so we're going to jump right into the program. And I just want to go through a couple of things with Judge Smith first. First of all, I just want to do our regular check-in. How are you doing this evening, Judge?
I am doing great, much better than I deserve. And I'm going to ask you a question, Steph. And what happened 101 years ago today?
That is not fair.
Well, does everybody have the answer? Anybody on the
I know we're celebrating suffrage.
The 19th Amendment was ratified in the Tennessee House of Representatives 101 years ago today.
101 years ago today. That's Daphne Davidson said women could vote. So
that's right. That's right. Young representative from Roane County, Harry Burns, followed his mother's suggestion, and he was the deciding vote that Daphne's asking, does she get brownie points? Of course you do.
Of course she does, but I mean, I really don't know how to give them to her. We don't ever see Daphne, but
that's right.
We'll stockpile
them. But one vote. He listened to what his mom told him, and 101 years ago today, women got the right to vote.
So the lesson here is listen to your mother.
Well, that's true, and I should have listened to mine a lot more.
Well, we think
fortunately she's no longer with us, but she's with me in spirit. Couple of things. One, for anyone that is interested, I'm having my campaign kickoff next Tuesday, the 24th, from 4:30 to 6 p.m. at the Homewood Suites down on 3rd Avenue, diagonally across from the new jail. So everyone is welcome. I hope to see you there, and hope we have a good crowd.
I think it's going to be a lot of fun, and it's going to be kind of an indoor-outdoor event. Is that right?
That's correct. And I am going to request that everybody wear masks. I think that's only appropriate with what we're going through right now. And on that note, beginning Friday of this week, we will start hearing the motion docket again down on the 5th floor in the spare courtroom. I won't be able to do that every Friday because we've got senior judges coming in and using that courtroom. But until we get through this spike of the Delta variant, I want to ensure as best we can, the safety of lawyers and litigants. And this weekend, when I get the numbers, I usually get them on Friday afternoon. We're going to make a decision, Stephanie and I will, about what we're going to do about going back virtual. We're looking at that right now. That is a real possibility. It slows down the entire process when we do like the ID dockets and the child support dockets virtually. But we're just going to have to do that. Contested cases, we're going to just take the precautions in the courtroom right now on the contested cases on Tuesday and Wednesday, and on the show cause docket, work from that. We just cannot get further behind right now. And anybody that's got, some sort of pre-existing condition that can't come in, certainly we will talk to you about, working with you virtually. But yeah, that's going to be something that we make the decision on next week.
And I just always like to reiterate to people, the best way that we have to communicate is on the circuit court clerk's website. in particular about our Friday dockets. And so if you go on the circuit court clerk's website, Ricky Rooker's website, and you click on the tab that says circuit, on the home page that says circuit, you'll see a lot of links that are in red type, and there'll be a section that says Fourth Circuit Court. Every week right now, we post our staggered motion docket there, and that's just the docket where we assign cases to a specific assign groups of cases to a specific time frame so that everybody's not coming to the court at the same time. But that's the vehicle that we use to make announcements about, what courtroom we're going to be in. If we're going to be virtual, if it's virtual, the login information will be on that docket where you can just click and log in, and you know what time you're supposed to log in. If we have other announcements that may not be relevant to the motion docket, we will still post it in that same place. It'll just be a different link that might say, announcement from Fourth Circuit Court dated whatever date it is or something like that. So that's the best way to keep informed with what we've got going on and decisions we're making. Of course, we will use other outlets to try to get the word out. We have a big database of all the addresses for attorneys, email addresses that we share with Judge Robinson, and we do an email blast. We will post on the domestic bar attorneys Facebook page. But that one website, on Ricky Rooker's website under the Circuit Court tab, is a very good place to get information as things, continue to evolve, and we're making decisions that will cause us to change course of action in terms of what we're doing and how we're doing it. So please be sure to check that each week or every day or whatever to keep informed as well. And you can always call us. We're there to help. You can always email me. And I'm happy to jump in and assist any kind of way. So yeah. All right. So we will get into tonight. Oh, before we do that, I want, Judge, we ended up postponing your domestic violence seminar that we're so excited about. Can you talk a little bit more about that and what we can look forward to as it relates to that in the future?
Yeah, we're looking at, in fact, we have moved it to November the 4th. And of course, we're going to do that in the AA Birch jury assembly room. But with the spike in the, COVID-19 Delta variant cases that we're having in Nashville, we just thought it was, not a great time to do it. And of course, Steph, you and I were on the phone call with Cameron and Monica over at the National Bar Association, and it was a unanimous decision to move it. But it's going to be a seminar that's really important. We've got a domestic violence problem in both in Tennessee and in Davidson County. We've had more domestic violence homicides through the first 6 months this year than we've had in most years, other than maybe a couple. We're gonna shatter the record, not a good record, this year. And we've got to start, doing what we can to prevent domestic violence. And in the future, I'm working on a plan, and I'm working with Diane Lance and Becky Bullard over at the Family Safety Center. And we're gonna take steps in the future to really work towards a major plan at treating the problems of domestic violence and treating the causes. If it's drug and alcohol issues, then there's going to be drug treatment. Attendance will be monitored by the court. Mental health, we're going to address those issues, batterers intervention, and we're going to monitor those. We anticipate we'll have a dispossession of firearms docket, where if they don't turn in, if a perpetrator doesn't turn in the affidavit, then they'll be on a show cause docket. And these are things we're working on. We're going to be working on the funding this next fiscal year. So, hopefully we can do something to start curbing the domestic violence issues that we're having. All cases are up across the board. And we got to do something about it. We just
Yeah.
have to do something about it.
I think it'll be a great CLE. So just stay tuned. We did reschedule it and it's going to be phenomenal. So I think, Judge, you wanted to make sure that it had the impact that it needs to have, and in person really does that a lot more than virtual, which is why we decided to move it versus going virtual.
Yeah, and either Diane Lance or Becky Bullard will be there from the Family Safety Center talking about red flags that lawyers should pick up on. Judge Philip Robinson, Judge Anna Escobar, Judge Special Master Ballinger, and I've got one more.
Judge Walker.
Judge Walker, yes. Judge Walker is going to be on the panel. I get to be the moderator, and they're going to talk about what they see, what the red flags are they see. We're going to have Rob Briley going to talk about TLAP and the different services they can provide lawyers. A lot of lawyers think that TLAP just deals with drug and alcohol issues. No, the more of these cases that you try, the domestic violence cases you deal with, the abuse cases that domestic lawyers have to deal with, there's a thing called vicarious trauma. TLAP can provide you counseling for that if you need it. And finally, Mickey Nelson, who happens to be one of my two best friends, he's going to be there to speak on personal protection. Lawyers taking, precautions, what they can do to protect themselves. And Mickey is a retired assistant director from the United States Secret Service. He protected 4 or 5 presidents, so he knows what he's talking about when he's talking about personal protection, personal responsibility. He'll be a great speaker, and so no, we're looking forward to it. It's going to be an interesting seminar, I think.
Yeah, it'll be great. Okay, so tonight's topic, we're gonna go back to the basics and talk about annulment, legal separation, and divorce. And I like to do it in that order because that's kind of a progression, I guess, of steps to separate from someone. Having said that, we got the vast majority of questions we got this evening centered around annulment, because it's that one thing that we rarely see. And that's so interesting to me because I teach at National School of Law now. This is my first term teaching family law. And last week was our first night. And so that was one of the things that we covered was annulments. And as I was teaching and talking to the students and giving the information and direction on it, I was really letting them know you really don't see it so much. So it's understandable why people would have so many questions centered around annulment. So I want to just generally talk about, how relevant is the whole annulment situation? How relevant are annulments? And what really qualifies for annulment? And that kind of gets into void and voidable things as well. So I kind of wanted to start off with that.
Well, annulment, first of all, is a creature of common law. There is no, while annulment is mentioned as divorce annulment, an annulment under Title 36, it is purely a creation of common law. So no statutory basis for annulment. It is alive and well in the state of Tennessee. Mm-hmm. And, there are several different grounds for annulment. But to talk about kind of the basic issues on annulment is you've got 2 different kind of marriages or annulment basis. One is that the marriage is void. And we all know the term from law school, void ab initio. It is void from the inception. There was never a marriage to begin with. One of those things is marriage between close relatives. That is a void marriage. You know, I mean, a void relationship. There is no marriage with annulment. You know, a pre-existing marriage, when you enter into the marriage contract, void ab initio, you cannot be cured. And then you've got the separate basis called voidable. And in Tennessee now, you have to be 17 years of age to get married. And, you know, this was passed a few years ago by Representative Darren Jernigan. And, you know, take for instance, you get married at the age of 15. All right, that's a defect under the marriage statute. But, you know, you and your spouse live together until, you know, beyond the age of emancipation or beyond the age of 17, then you've kind of cured that defect in the marriage. And so that's voidable. It's not void from the inception. The parties choose to continue in the marital relationship until the defect is removed. And, you know, these are treated two different ways. One thing that you look at is it can have an effect on an alimony award from a previous divorce. In other words, if the marriage is void, and Steph, you'll correct me if I'm wrong, and the court declares it a void marriage, then the alimony obligation from that previous relationship can go back into effect. It's not so on a voidable marriage. It's that, you know, alimony obligation from the earlier divorce stays dead, so to speak. It can't be revived. And that's an important distinction there. In regard to grounds for annulment, there's, let's see, party under the age of 17 at the time of the marriage. That's one thing. A prior existing marriage at the time of the, you know, entering into the marriage contract, and the defendant knew the former spouse was living. Okay. Another one is a refusal to cohabitate or consummate the marriage. Mental incapacity. Do you have the ability to form the intent to get married? Mm-hmm. Impotency, which existed prior to the marriage, not that is suffered after the marriage. Duress. You know, we've all heard of back in I think it was the show, the Beverly Hillbillies, it was Andy Griffith's show, a couple of shotgun weddings, you know, marriages performed under duress. You know, the shotgun was held at the groom or the bride's head. Obviously, that is a basis for annulment. And then fraud. Generally, we see fraud, and it's titled fraud calculated to induce the marriage. But we usually see that in pregnancy by another at the time of marriage. And, you know, those are basically the grounds for annulment. And, you know, annulment is not used a tremendous amount of the time, mm-hmm. but I probably see one or two cases a year. Now, I want to point out that there is a ground for divorce, and it's entering into a second marriage while having a prior one. I think you have to look at the annulment and what it accomplishes versus the ground for divorce. People may be wondering, well, wait a minute, that's a void marriage if there was a pre-existing a marriage, and that's true. But let's look at this. What does the divorce ground assume that the annulment does not? The divorce assumes a valid marriage. Okay. Now, on annulment, generally you can't get a division of property, you can't get alimony, you can't get attorney's fees. All of these things are kind of outside of what the court can do. There was no marriage. The marriage did not exist. So if you've got a person coming in who is claiming, particularly the party that is engaged in the wrongful behavior, if you've got them coming in, and that it happens, look, we engage, me and my second wife, or my second spouse, we engaged in the marriage ceremony, and I wasn't divorced yet. So my marriage to my spouse is void. And I'm using void instead of voidable, but it's void. So I don't have to pay my spouse alimony. I don't have to divide anything that I've accumulated during the relationship. And so that spouse is kind of out in the cold. I think a good strategy is, if you get a petition for annulment and your client is the innocent party, what do? Turn around and file a counter complaint for divorce and allege the grounds that your spouse entered into a second marriage while having a prior one. And I think that really kind of alleviates a lot of the draconian effects of an annulment. And so, that statute's there for a reason. A lot of people don't think about using it, but it's good to know about and good to use as kind of a defensive / offensive strategy when you do get served with a petition for annulment.
Yeah. I think that's great. That's perfect. And it's useful because, again, we don't see the annulment so much, so people just are not in the habit of the practice of going through an annulment. But it can be something that does come up. You're right. We will see it, once or twice a year, and it typically is really important. A lot of times, I think when we've seen it in a contested sense, especially, is when somebody was married was married at the time they got into the second relationship, or whatever the case might be, that they had not been divorced from the previous relationship. And it definitely deals with, has an impact on the marital property and what we can divide, or any of those types of things. So it's very helpful. I want to move on now to legal separation. And why in the world would somebody want to do a legal separation versus getting a divorce? Why not just get divorced? What is the point in legal separation?
Well, legal separation, when I first started practicing, wasn't in existence. I noticed Brenda Clark was on here a minute ago. Some of the lawyers that had been practicing for quite a while will recall the old divorce amends a thorough, which was part of the statute, a bed and board divorce. That's what was used originally as a legal separation. And quite frankly, the legal separation is similar in some ways to the old divorce amends a thorough. But, you may want to use a legal separation for purposes of medical insurance. Now, with the ACA, we may not have that same need, but say your spouse is a cancer survivor, but yet they're inside of that 5-year period. When they say you're kind of cancer free, it may be difficult for that spouse to get insurance, and it may be very expensive. But just keeping the status of the marriage intact will generally allow that spouse to remain on the other spouse's policy. So it may be a financial reason. It may be a situation where the parties aren't quite sure They want to completely sever the relationship. They want to define their rights and obligations and live separate and apart for a period of time. That may be a reason to use a legal separation.
Yeah, so wouldn't that be like testing out a divorce? Like,
Well, it could be. I think probably more important is to come up with a concept where people test out marriage before they enter into it.
that would
And
be a wonderful concept.
yeah, might make my job a little easier.
Probably, but probably not. People,
Yeah, that's true.
there's something that's exciting to people about getting married. It's easy to do and a lot harder to get out of it. But when you talk about legal separation and, people doing it, I've definitely seen it where people were trying to maintain some kind of financial benefit, an insurance benefit or something like that. So they really didn't want, they really were done with the relationship, but they could still benefit from each other from that standpoint. Um, but isn't a legal separation, I mean, don't you pretty much divide up everything and address issues the same way you would in a divorce?
Yeah, the same. Excuse me, I lost you. Hold on
Uh-oh.
just a second.
I still see you, Judge.
Okay, now I see y'all. All right. Yes, I mean, the same statute applies. Division of property. If the court has to try it and has to divide property, the same statute, 36-4-121, applies. If alimony is involved, it applies. If children are involved, still got to do a parenting plan.
Mhm.
The guidelines apply. So yeah, you actually have to prove grounds too.
Mhm.
And they added a few years ago, they added the additional ground to legal separation of irreconcilable differences. And really, the only thing different in that situation is instead of a marital dissolution agreement, it's really referred to as a legal separation agreement.
Mhm.
And parties have the option also. Um, they can do a legal separation and not divide property. They can do a legal separation and go ahead and divide everything.
Mhm.
If that happens and the marital property is divided, then any after acquired property during the legal separation goes strictly to the party that acquired it. And that's a great thing too.
If they
Particularly,
divide the property,
I'm sorry.
if they divide the property as
If
part of
they
the legal
divide the
separation.
property and that kind of thing, any after acquired property belongs to the person that acquired it. And that's really a good way to do it if you're doing the legal separation for something like maintaining insurance, because after 2 years, either party can move. Either party to a legal separation can move for a divorce, and if grounds have occurred during that 2 years or prior to the expiration of that 2 years, then the innocent party can go ahead and ask for an award of divorce based on those new grounds.
On the new grounds.
Mm-hmm. And an example would be, legal separation. You're still married,
Right.
but what if you, engage in a relationship with a significant other while
That's
you're
what
still
people are
married?
going to do in a legal separation.
I'm sorry.
That's what people are going to do in a legal separation. I mean, they're,
That's that's right, but that's adultery.
it
If
is because you're still married.
you're still married, and a lot of people, particularly young lawyers, view the ground of adultery. Well, it's not what caused the breakup of the marriage. Well, that may be true, but if you read the adultery statute, it doesn't matter whether adultery was or was not the cause of the breakup of the marriage. Adultery can take place the night before final hearing. So it's a valid ground all the way up to the time the court bangs the gavel and declares the parties either legally separated or actually divorced, not legally separated.
So I think that's a great segue into talking about grounds. If I were in the legislature And thank God I'm not with everything that's going on up there right now. I would be advocating, and I know that there's a lot of this is controversial what I'm going to say, but I believe it. I would really be advocating for us to become a no fault state because I'm really I really don't appreciate grounds as they exist today so much. Um, because at the end of the day, if two people want to be divorced, why is it so necessary to fight about the reason they're getting divorced? So, and I guess at one point, and I guess still, the government wants to promote marriage and protect family and things like that. And so they just don't want people willy-nilly just up and leaving. But that's what's happening. I mean, like, it's not that useful anyway. I see people expending a lot more time and energy and money in harping on issues about grounds when really we should be getting right down to the brass tacks about the issues of the division of property or the alimony or the children. So why are we still fooling with grounds? Why are grounds so important?
Well, actually, grounds used to be the everything in the divorce. We're a fault-based state, and back during the 40s and 50s, you had to really have solid grounds, really solid grounds, or you couldn't get a divorce. The Reconcilable Differences divorce statute came into effect, I think, in about 1983. And after the statute came into effect, kind of started to see a slow trend in the change of public policy. If two people were living together and one wanted out of the marriage, there's really no reason to keep the status of the marriage intact. You can't make them be happy. You can't make them be good parents. You can't make them be good providers. So why do we leave these people in that relationship? And it's evolved since 1983. And when I first started practicing, grounds were tried regularly. And then I guess maybe around, I want to say 92 or 93, the legislature enacted TCA 36-4-129B, which is the stipulation for grounds. And it also, the parties can stipulate, yes, if the case was tried today, the proof would establish that I've committed inappropriate marital conduct, or my spouse has committed adultery, or, they could stipulate if they've got a marital dissolution agreement and a parenting plan, they can stipulate irreconcilable differences. Additionally, the court, after hearing, rather than give the grounds of divorce, award the divorce to one party or the other, the court can simply declare the parties divorced. Or after hearing the proof, the court can find that while both parties have grounds, one party is more at fault for the demise of the marriage than the other party. Mm-hmm. So 36-4-129B has gone a long way in kind of taking the wind out of the sails of grounds. Now, I will tell you, sometimes grounds can be used in a very offensive manner. In other words, you've got a wronged spouse, let's say adultery is involved, and you've got the wronged spouse who is taking this and really wanting to punish the other spouse mm-hmm. because of that spouse's misconduct. Mm-hmm. And if it's really tough to deal with that in that situation, excuse me. Mm-hmm. And so, what do you do in that situation? I have always thought that if the ground was adultery, why not go ahead and admit it rather than allowing the other spouse the ability to really kind of crack you over the head with it?
Yeah, because really, how much do grounds factor into your bottom line when you're dividing assets and debts?
Well, obviously, on dividing property, I cannot consider it.
Right.
Absolutely cannot consider it. Uh, you know, maybe a little bit in a custody fight, depending on which grounds there is. If there's domestic violence, if there is, vile and ugly language used towards the other spouse in the presence of the children, conviction of a felony, obviously. These are things you may consider in a custody fight. The statute still requires um, a consideration of fault in an award of alimony. Quite
Mhm.
frankly, it really means very little, very
Mhm.
little. Need, ability to pay, and standard of living are always the mainstays in an alimony award. Uh, Attorney's fees, in theory, it could matter. I don't look at that, particularly with the modifications to 365103. I don't consider fault really in an award of attorney's fees. So outside of, those unique cases where grounds may go to something related to the child or children, grounds really means very little.
And as it relates to going to issues that the court will consider when looking at the factors for best interest and making a determination about custody and parenting time, you can still raise those issues and the facts related to them without them having to be part of ground, so to speak. Yes, no?
Absolutely, you can. And it's always kind of funny. A lot of time and resources are used on establishing grounds when overall, when you're trying a divorce that involves most all of the issues, it's probably the least important one.
Mhm.
Now, it used to be before we had mediation that grounds, and it's still true to a much lesser extent now, but grounds was kind of therapeutic
Mm.
to the wronged spouse, and we still see some of that now. But in depositions and in mediation, the wrong spouse is really being able to tell their story, particularly in mediation and judicial settlement conferences, to a disinterested neutral. And when you get to tell your story, there is something that appears to be therapeutic. We've all had those clients that say, look, I know what you're saying about the money. I know what you're saying about the kids, but I want to tell the judge my story.
Yeah, no, that is very true. I think the other side of the coin to that is that people want to kind of use the court and the judge to be able to tell on their spouse, right? I want somebody who's bigger than me, who has more authority than me, to know that my spouse has done this, and I want them to like really give it to them because I can't. And then they come to court with that expectation. And A, we've heard it all before. And B, like you said, when you really get down to what you're considering in the case and the decisions you're making, it may not be such a big factor. They're really not getting this big show and being fulfilled the way they think that they are going to be.
Yeah, I mean, it's that outlook. I tell the judge my story. The judge is going to view this as the worst case they've ever seen, and they're going to wave their magic wand and make everything all right. Well, it unfortunately, or fortunately, depending on how you look at it, it doesn't work that way. Now, it did at one time. Fault was everything back during the 40s and 50s. It was everything. But now, cannot consider it in a division of property. It really doesn't come into play much at all in alimony. How do you quantify fault for purposes of alimony? How do
Mhm.
you quantify that? Need and ability to pay and standard of living are pretty easy things to quantify. Fault, how do you really factor that into the equation. And, on attorney's fees and children, it's just a lot of times people could save a lot of money, a lot of attorney time and stipulating grounds. And, if you've got the client that is the one that is at fault, instead of trying to justify your client's behavior, why don't you take it out of play and think about admitting it or stipulating to it later? If you're later on in the process, what you're doing is you're really taking it out of play. So you're kind of stealing the other side's thunder, so to speak.
Absolutely. Yeah. And one thing that I will say, and I say this about you often, Judge Smith, and I have the benefit of watching you in court day in and day out. And one thing I really think it's a gift, every judge does not have it, is that you have the ability to hear facts that can be very disturbing to you. Someone's behavior can be very upsetting to you or very disturbing to you. And you might even let them know that. But when it comes down to the ruling and looking at the issues and applying the law, you are still very fair. And so, you don't allow your disdain for someone or something that has come out in the proof that is upsetting to you ultimately affect your ability to be equitable, serve, make decisions on the best interest of the children and things of that nature, just because someone has upset you. And I think it's important for people to know that, because it helps them understand really how much energy to put into that anyway.
Well, I thank you for that, and I'm honored you said that. I'm sure there's some lawyers on the call that may disagree with you, but
They might.
But
that's why I said I get the benefit of seeing you day in and day out. Nobody else is there every day other than the staff, right?
That's right. That's right.
So,
let's talk about grounds right now.
I'm sorry?
Let's talk a little bit about grounds.
Yeah, let's talk about grounds. Let's go at it. All these
well,
grounds
let me get to
what they are.
My notes here. We've got actually 15 different grounds for divorce in the state of Tennessee. And some of these you're gonna kind of detect a little bit of similarity to the grounds for annulment. Grounds for divorce: impotency at the time of marriage, of the marriage contract, and incapable of having children. That's a ground. I have to say, I have never really seen that one used. I could see circumstances where it would be used. I could see where it was very important back, 50 or 60, 70 years ago. Maybe a little less so now, but it is alive and well. Of course, one of the grounds, entering into a second marriage while having a prior one, we've talked about that. Adultery, and it is defined as sexual intercourse with another person other than your spouse. And we will leave that at that.
But just let it be.
Yeah. It is alive and well. We see adultery quite a bit. By the time people get to trial, maybe they have decided to stipulate grounds or enter into a stipulation that the court simply declare the parties divorced. And that's a good thing. I mean, there's a lot of anger, particularly early on in a divorce case where one spouse has cheated on another spouse. And, there's nothing we can do about that. But again, if you are the guilty spouse, you may want to kind of steal the other side's thunder and think about admitting that in an answer or stipulating to it later on at trial. We've got one that we do see, not tremendously, not a tremendous amount, but willful desertion without reasonable cause for 1 year. And that is alive and well in Tennessee. Again, it's got to be without reasonable cause. You know, you can't run and get an order of protection against your spouse and then complain, you know, that they're guilty of willful desertion because they hadn't been to the house in a year, hadn't been part of the household. It's got to be without reasonable cause. That order of protection in that circumstance would be the reasonable cause that would prevent that that from being a provable ground. And you know, the desertion must be willful also. Another one, and this is one of my favorites because it is so easy. You know, we have two witnesses in Davidson County on default cases, and those are directed towards grounds, those two witnesses. But conviction of a crime rendering one infamous. And Tennessee Code Annotated 40-2112 defines what infamous crimes are. And I don't have a list of them, but they are getting to be fewer infamous crimes, and a lot of it is dealing with the right to vote by people that have been convicted of crimes. So that's not as big a deal. I mean, not as big an area for that's right for a ground as it once was. But there is a separate ground, conviction of a felony during the marriage. And it's got to be, of course, a felony involves punishment of over 1 year. But what is so easy about that ground is all you have to have is a certified copy of the conviction, which you can get from the criminal court clerk's office. If you bring the certified copy of the conviction, you don't have to have any witnesses. It's a real easy ground. All you do is hand it into the judge. I'll look at it, look at the dates of the marriage, and make the decision on that ground. It's really, really an easy ground. This is one of my favorites. Attempt on the life of the other spouse by poison or means showing malice. Wow.
Yeah, I mean, if you're doing your job, like, A, it's not going to be attempted, and B, there's no need to get divorced because
yeah,
they'll be gone.
You know, back in the day, you know, when arsenic was kind of difficult to be detected, so you know, I could see that at one time it may have been a very thriving ground for divorce in Tennessee. You know, still you got the, you know, if your spouse has a shellfish allergy and you slip a little shellfish into the into the mushroom bisque, yeah, I guess maybe that might satisfy the ground. I don't know. Like I say, I've never seen it used, and quite frankly, don't really know the history of that ground. Another ground for divorce in Tennessee is refusal to move to Tennessee without reasonable cause and being willfully absent for 2 years. Now, that ground was enacted by the General Assembly in the year 1819. Okay. Now, why is that kind of important? You know, what does that ground stand for? West Tennessee had kind of a frontier a reputation. And, you know, why do you want to, you know, move with children if you're, you know, say a wife and you've got children? Why do you want to move your children to an area that may be dangerous because of various reasons? You may not want to do that. That's where that ground came from. I believe it was probably part of the original common law of the state before it was codified.
Mm.
But kind of makes sense. Let's see, pregnancy at the time of the marriage by another person without the knowledge of the husband. Well, we can see that is a valid ground.
That's valid.
See that on occasion. But the problem in proving that ground is it's always going to be the wife says, well, he knew about it. And he's going to say, well, no, I didn't. So it's a matter of proof on the knowledge on the part of the husband that is the problem with that ground. So we see it, but it's always difficult. And most of the cases I've tried, the husband actually knew. And it's and I kind of look at it as a known or should have known, but they knew they wanted to provide for the child. They wanted to be a parent to the child until the divorce comes around, and then there's this thing we call child support.
That's right.
We see this a lot. Habitual drunkenness or drug use contracted after the marriage or without the knowledge of the innocent spouse if it existed prior to the marriage. What we generally see is habitual drug use or alcohol use, habitual drunkenness or drug use, and it's usually drug use. It's a lot less habitual drunkenness, but we're seeing a lot of it because of the opioid addictions that run through the court. And these are people that are coming through that have gotten addicted to opioids, maybe because they've had maybe surgery on their shoulder, on their knee or something, and they've had to deal with the pain, and they've received prescriptions for Oxy or Loratab or whatever. And, that is acquired after the marriage. And so that I won't say we see it every day, but we do see it, I'd say probably at least a dozen times a year. Cruel and inhuman treatment or inappropriate marital conduct, both are the same thing. When I was in private practice, I used to tell people that if you've been married 30 days, you probably have grounds against your spouse for inappropriate marital conduct.
Very true.
It could really be anything that results in a pattern of irritation or discomfort inflicted on one spouse by the other. A lot of times it may be vile language that is used on a regular basis, running your spouse down, really talking down because of a lack of education, talking in a very derogatory manner about their parenting skills. All of this, all of that's inappropriate marital conduct. And inappropriate marital conduct has really lowered the bar on grounds. And, it's like I say, if you've been married 30 days, you can probably dig enough to find grounds, on your spouse. But those are by far cruel and inhuman, inappropriate marital conduct. They're the grounds that we see more than any other than irreconcilable differences.
And someone put a question in the chat to discuss the difference between inappropriate marital conduct and indignities to the person.
Well, indignities is more of a specific ground, and where such indignities are offered to the other spouse, causing them to withdraw. And again, that is also usually verbal barbs, calling names, just degrading someone on a regular basis. It's more of kind of a specific inappropriate marital conduct. Inappropriate marital conduct is kind of the umbrella. Indignities is just a specific aspect of inappropriate marital conduct, but it's usually usually associated with some form of verbal abuse. Abandonment, that amounts to refusing or neglecting to provide for the other spouse while having the ability to do so. We see abandonment. We see it a lot of times. We'll see it on the default docket where parties maybe have been married for 20 years but hadn't lived together for the last 10 years. And it may be that, one day the the spouse comes home from work and the other spouse is gone and they never see him again. That's the type of situation that we see abandonment, involving abandonment, but it is a valid ground in Tennessee. The other, the last actually contested ground I'm going to talk about is 2-year separation statute with no minor children. The parties live separate and apart for 2 years, and they don't have any married children. That is the ground for divorce. Really can be addressed with, 3 or 4 questions. When did you and your spouse separate? Such and such a date. Have you and your spouse lived together as husband and wife, or husband, wife and wife, whatever, for 2 years since that date? No, we have not. Do you have any minor children? No, we do not. That really is the ground in and of a nutshell. Very easy to use. A lot of lawyers don't use 2-year separation, but I think it's a good ground. Particularly if you're gonna have a case where the parties have lived separate and apart for 2 years, no minor children, maybe they've lived together for a few years, and there's going to be a dispute over the marital estate. Go ahead and get grounds out of the way. Let's get to the division of property.
Yeah. We have a question from Lewis Williams. If a party admits to fault, such as adultery, let's say just they admit to it in their counter complaint or whatever the case might be, how much discovery is permitted for the other party on that issue? He's had clients, and I've definitely seen it before, that want to just get messy about it and depose the paramour, and almost kind of in a harassing nature. They just kind of they don't want to let their claws out of that issue, even though it's pretty much like, we're over that. That's done. Let's move on.
Yeah, I think there is some discovery that can be done on it. One, I think, and I think the Boatman versus Boatman case backs me up on this. I think a spouse has the right to know who. And you're probably saying, well, wait a minute, they've admitted adultery. Why who? Well, one, you may have money spent on that person.
Right.
So you've got maybe a dissipation issue. So that's fair game. Money spent on that person, gifts given, out of town trips. I think all of that is discoverable, because remember, now the bar is so low on discovery. What is relevant for discovery is now a different standard than what is relevant at trial. And, at trial, if there's no money being spent, and there's no dissipation issue, all of a sudden those other issues may become irrelevant. So, but discovery is a different situation. I do think that's fair game. And look at the Boatman case. It will tell you specifically, and obviously, if sexually transmitted disease is involved,
we've seen it.
The person who received the sexually transmitted disease needs to know all of these other people that the spouse has had sexual relations with.
So a good number of our questions tonight that came in before our program tonight and during the program, a lot of them you addressed just in talking. There was one that I want to close out with at 7:00, and that was, how do you work so hard and stay so good looking?
Is Scott Parsley on this somewhere? I know he probably asked that question. But it could have been Lewis. Lewis, was that you that asked it? Well, one, I do work hard, but I'm certainly not good looking, and that. Wow. Anyway, I'm gonna close this out blushing.
Oh. Well, thank you all for joining us tonight. We hope to see you September, the third Wednesday in September at 6 o'clock. We'll be right here with more information on Family Matters with Judge Bill Smith. Good night, everyone.
Thank you all, and thank you, Stephanie.
Thank you, Judge.